Hello and welcome, everyone. Just a minute to see if a few more people trickle in, and then we will get started. Welcome to our new arrivals. Our participant counter is slowly filling up. So once it when it levels out, we will begin. All right. With our participant counter has stopped bumping up. Thank you all so much for coming. Let's get started. All right. Hello and welcome, one and all, to Melting Ice and Modern Technology, Naval Warfare, and IHL in the 21st Century. My name is Ben Crawford. I'm a legal fellow with the American Red Cross IHL team, and I have the pleasure of speaking to you live from the American Red Cross National Headquarters here in Washington, D.C. Over the next half hour or so, I will be presenting the framework of international humanitarian law applicable to naval warfare. Ideally, there will be some time for questions at the end, so please do not hesitate to use the Q&A function throughout the presentation if you are so inspired. But with that, time is short and lunchtime is important, so if you'll forgive the pun, let's dive right in. The ocean is an incredibly important global thoroughfare for both economic and security purposes. Approximately 80% of the international trade in goods is carried over the world ocean, which covers roughly 71% of the planet's surface. As the global balance of power continues to shift and sea levels continue to rise, oceanic conflicts are increasingly likely amidst this changing strategic frontier. That is why it is certainly important to discuss the existing IHL framework applicable to naval warfare. Prior to discussing some of the laws of naval warfare, it is important to review some of the overarching law of the sea that can provide a useful foundation for what's to come. The law of the sea is largely codified in the United Nations Convention on the Law of the Sea, or UNCLOS. UNCLOS was adopted in 1982, and it lays down a comprehensive array of rules governing all uses of the ocean and its resources. There are currently 169 parties to the treaty, and it is also now considered customary international law, which means it is therefore binding on all states. UNCLOS establishes legal demarcations of areas of the sea that have different rights and statuses, including territorial seas, exclusive economic zones, and the high seas. A territorial sea extends 12 nautical miles out to sea from a set coastal baseline. The territorial sea is an extension of a coastal state's sovereignty, with all the same rights and protections incumbent with territory made up of solid land. The exclusive economic zone of a state is an area beyond and adjacent to the territorial sea that shall not extend more than 200 nautical miles out from that same coastal baseline. In the exclusive economic zone, the coastal state has sovereign rights for the purpose of exploring and exploiting any natural resources for the purpose of in the waters, on the surface, on the seabed, and in the subsoil. Last, but certainly not least, the high seas comprise all parts of the sea that are not included in any state's exclusive economic zone or territorial sea. Ships of all states can traverse all of these areas due to the right to innocent passage and the right to freedom of navigation. The right of innocent passage stipulates that ships of all states may pass through a coastal state's territorial seas, provided that their passage is innocent. Passage is innocent as long as the passage is not prejudicial to the peace, good order, or security of that state. Some examples of prejudicial conduct include the threats or use of force against the coastal state, any exercise or practice with weapons of any kind, acts aimed at collecting information to the prejudice of the defense or security of that coastal state, or even just fishing without permission in the territorial sea. Freedom of navigation stipulates that ships of all states have the right to sail ships flying their flags on the high seas and in other states' exclusive economic zones without interference. So as you can see under UNCLOS, it is quite easy for ships flying the flags of many different states to all be passing through one area at the same time, which can make situations of armed conflict at sea all the more complicated. With that in mind, we can turn now to the law of naval warfare itself. Now, you may have been wondering, why, really, is there a distinct body of law specifically addressing naval warfare? The major difference that likely would come to mind is that it's the area in which the armed conflict actually exists. Land warfare, wouldn't you know it, takes place on solid land. The conduct of hostilities at sea takes place in, under, and above sea areas that also continue to be used by international shipping and air traffic. International humanitarian law for land warfare focuses on the regulation of the conduct of hostilities and the protection of non-combatants, detainees, victims, civilians, and civilian objects. The rules on targeting and attack are focused on the status of individuals. Now, while the core principles of IHL apply both in land and in naval warfare, IHL for the law of naval warfare is more concerned with the status and targeting of objects and platforms, such as ships and aircrafts, than the targeting and status of individuals on said ships and aircrafts. Additionally, the law of naval warfare has an element of economic warfare, where warships and military aircraft can, in certain circumstances, capture enemy or even neutral vessels, aircraft, and goods. Unlike the law of land warfare, the law of naval warfare engages in a balancing act between the competing interest of, on one hand, the parties to the conflict who wish to defeat their enemy, and on the other hand, the interests of neutral states who wish to guarantee their merchant vessels the freedom to engage in maritime trade. This is why the framework for the law of naval warfare can be composed into three separate aspects. First, the main focus of this presentation, the conduct of hostilities. This includes the means and method of warfare, the rules of targeting, and the duty owed to the protection of persons and objects at sea. Second, we have prize law, which includes the capture of vessels, aircraft, and goods under certain circumstances. Third, finally, maritime neutrality. Maritime neutrality includes the rights and protections accorded to neutral states and their territories, which strives to prevent conflicts from increasing or growing in the number of parties involved. The foundation for this framework comes from a series of treaties. So we see here we've got the Declaration Respecting Maritime Law from 1856, a series of Hague Conventions relating to the conversion of merchant ships, submarine contact mines, bombardment of naval forces, exercising the right of capture, all from 1907. The process for Naval, which I've definitely pronounced wrong, relating to the rules of submarine warfare from 1936, the Geneva Conventions from 1949, and Additional Protocol 1 from 1977. As you can see, with the exception of the Geneva Conventions and their additional protocol, all of these treaties are incredibly old, and their relevance in the modern era is a matter of some debate. For some fun historical context, the transition from sailing ships, with wood and iron to steamships was happening in the late 1800s into the early 1900s, right when these treaties were coming into form. Fortunately, the lack of contemporary law was noticed in the late 1980s, which led to the creation of the San Remo Manual. The San Remo Manual on Armed Conflicts at Sea was created between 1988 and 1994. It was intended to be a contemporary restatement of international law applicable to armed conflicts at sea. The manual combines not only the traditional naval warfare, but also developments in international humanitarian law that developed after World War II. While it is not a binding legal instrument, it is widely considered to be a codification of customary international law and is extremely persuasive. With that in mind, I will now turn to reviewing the actual conduct of hostilities, but for the purposes of time, I'm only going to be focusing on vessels and ships, not aircraft, which have a slightly different framework. The conduct of hostilities operate under the 4 core principles of IHL. Proportionality stipulates that the parties must refrain from engaging in attacks which must be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination of these that would be excessive in relation to the concrete and direct military advantage anticipated. Principle of necessity allows combatants to only engage in acts of war as necessary to secure the complete submission of the enemy as soon as possible, as long as the acts undertaken are not in violation of IHL. Principle of distinction requires that parties to the conflict at all times distinguish between the civilian population and combatants, and between civilian objects, exempt objects, and military objectives, and direct their operations only against the military objectives. It aims to protect the civilian population and civilian objects and is considered the relative grandfather of all the other principles. Lastly, we have the principle of humanity, or the prevention of unnecessary suffering, which prohibits the employment of weapons, projectiles, materials, and methods of warfare of a nature that cause superfluous injury or unnecessary suffering. Now, historically, the law of naval warfare was primarily designed to apply in international armed conflicts between states with their great powers fighting in wars. And therefore, as you saw, many of the treaties regulating armed conflicts were adopted before non-international armed conflicts were as common, before 1949, and in times when non-international armed conflicts were not even recognized as much as a matter of international law. Nevertheless, today, the law of naval warfare does apply to non-international armed conflicts that extend into the sea as much as in terms of the principles of international humanitarian law that provide provisions for the conduct of hostilities and the protection of civilian objects and victims at sea. Diving further into the conduct of hostilities, means of these hostilities. We have mines, torpedoes, missiles and rockets, lasers, incendiary weapons, directed energy weapons, and drones are all frequent and in increasing prominence in the navies across the world. Mines are a permissible means of war if they are lawfully employed. To be lawfully employed, mines must be used for legitimate military purposes. The deploying party must be capable of effectively neutralizing those mines. They must record the locations of the mines, and mines cannot be deployed into neutral waters. It is forbidden to use free-floating mines unless they are directed against a military objective and they become harmless within an hour after the loss of control. This is one very key aspect in naval warfare and just the nature of the ocean in general. You're not always positive that when you leave something somewhere, it's not going to move. And so IHL goes forward and attempts to balance that out by saying, hey, yes, you can put mines, they can be free floating, but after a certain point of time and a certain military objective has been completed, you have to render them inoperable automatically to prevent any incidental loss of life or injury. Torpedoes are a permissible means of war as long as they sink or otherwise become harmless when they have completed their run. This is very similar to the logic behind mines of things in the ocean can tend to, if they miss, stick around. And by including these provisions in IHL, it acts to ward off some of the inadvertent detonations and injuries that, while they can happen with land warfare, they're a little more contained. Whereas if a ship or a vessel bumps into a torpedo that was left from a former war, or a neutral vessel hits a torpedo left from a conflict earlier that day, it could bring other parties into the conflict and could cause very large injury and loss of life if a ship is sunk or severely damaged. Missiles and rockets are lawful as long as they're employed with the principle of distinction and the other core principles. Lasers, increasingly common. There are several types of lasers being employed in naval warfare. First off, there are lasers that can blind personnel on opposing ships. Blinding lasers are permissible if they are lawfully employed, which, to be lawful, any blindness caused by those lasers must only be temporary. This is codified under the Protocol 4 of the Convention on Conventional Weapons, which specifically addresses blinding lasers. If the laser is an incendiary laser, it is not covered by the Protocol on Incendiary Weapons, and can be permissible as long as it complies with the core principles of IHL. Incendiary weapons specifically, ones that use chemicals and other substances to cause flames to ignite, are permissible as long as the target is not near a large concentration of civilians. Moving on, directed energy weapons. This is something that is currently being developed by several states, including the United States and Russia. Directed energy weapons are currently being developed for use in naval combat. They use electromagnetics to convert chemical or electrical energy into radiated energy, which is then focused on a target, causing physical damage. This can include forms of lasers and radio and microwave rays, which can incapacitate, disable, and destroy enemies' equipment, facilities, and personnel. Presently, directed energy weapons require a lot of energy to use, which is making them quite suitable to be something that is mounted on a ship. Similarly to our other means and on this list, directed energy weapons are permissible as long as they comply with the core principles and do not cause any unnecessary suffering, or can be used without operating distinction. Last but not least, we have drones, which are getting more and more advanced. The drones are currently both a means of warfare and are rapidly becoming potentially classifiable as a warship or an auxiliary vessel, as a standalone ship with some of the rights and obligations that engenders. But the use of drones, such as the simpler ones that just move through the water somewhere and launch a missile, or any kind of varying complexity, are also lawful and permissible to use as long as they comply with the core principles of IHL. Moving now to methods, we have blockades, deception, and sea control. A blockade is an operation intended to prevent ships from all states from entering or leaving specific coastal areas that are under the control of an enemy. This can include ports, harbors, parts of a coast, or an entire coastline, if need be. All aspects of a blockade, including the geographic extent, the dates of the blockades, the scope of the measures employed, must be declared by the imposing state, both to all enemies and neutral states. A blockade must be effective, applied impartially to all states, all ships, and must not bar access to the ports and coasts of neutral states. A merchant ship believed to be breaching a blockade may be captured. And if a merchant ship ignores warnings and resists capture, it may lose its protection and be subject to targeting and attack. Blockades are prohibited if it has the sole purpose of starving the civilian population or denying it other objects that are essential for its survival. Or it is prohibited if the damage to the civilian population is or may be expected to be excessive in relation to the concrete and direct military advantage anticipated from the blockade. The blockading state may also make arrangements for the provision of humanitarian support to a blockaded area. When it comes to deception and naval warfare, ruses of war are allowed, but perfidy is not. What this means is that ships can use a false flag to feign neutral status and therefore escape detection or attack from enemy ships. But it is very important that these ruses of war do not extend into perfidy, and ships using a false flag cannot initiate attacks while flying said false flag. Further, warships cannot simulate hospital ships, humanitarian ships, civilian passenger vessels, United Nations vessels, or vessels granted safe passage by an existing agreement between parties to the conflict. Lastly, we have sea control. Sea control is a method of ensuring control over an area and denying access to that area to an enemy. It is intended to prevent an enemy from gaining access to or passing through an area, and if an enemy does gain access, making that environment as hostile as possible for them to detract from that effort and slow them down. Sea control can include the creation of maritime operational zones. Zones must be declared and notified both to enemy and neutral states, as with blockades. And they can have any scope or purpose that is lawful within the existing legal framework of naval warfare. So a blockade can, or excuse me, a maritime operational zone can stipulate that all neutral vessels passing through must stop and consent to a visit and search by a warship and auxiliary vessels. It might say that neutral vessels have to take a certain path and divert around certain areas, and more. Non-compliance with a zone's requirements could render a vessel a targetable military objective or lead to it being captured and potentially subsequently condemned as a prize under prize law, which we will discuss a little further on. Zones can be defended not only by warships and patrols, but by the laying of sea mines, as long as they comply with the rules discussed on the previous slide. Turning now to targeting, we have warships, auxiliary vessels, merchant ships, and neutral vessels as 4 categories. Now, neutral vessels are a status, while the other 3 are different types of vessels. A warship, a merchant ship, or an auxiliary vessel can be a neutral vessel, but it has specific conditions that we will get into a little bit now. So, a warship is defined as a ship belonging to the armed forces of a state bearing the external marks distinguishing both the character and the nationality of such a ship, which includes both surface and underwater vessels. Enemy warships, whether manned or unmanned, are valid military objectives that can be targeted at any time unless they're in neutral waters, and they may be targeted regardless of the composition of the crew or the passengers on board. This is one of the key distinctions between the law of naval warfare and the law of land warfare, as the law of land warfare would provide, if you're attacking, say, a military installment, you have to analyze, is it a joint use building? Are there civilian operations as well as military operations ongoing, and how to mitigate that? But when it comes to targeting warships, the fact that it is a warship means relatively unequivocally it is a valid target. Auxiliary vessels are vessels other than warships that are owned or under exclusive control of the armed forces of a state and are used for governmental non-commercial service. Similarly to warships, Auxiliary vessels, whether manned or unmanned, are valid military objectives that can be targeted unless they are in neutral waters and regardless of their composition of the crew or passengers on board. Merchant ships. Merchant ships can be allied, enemy, or neutral. And the question is, you're on a ship and there's a ship somewhere else, and how do you know without going to search that ship directly, how do you know if they're friend or foe or either? And that comes in with flags of nationality. Flags of nationality are conclusive evidence of a vessel's enemy or neutral status. However, if a warship suspects that a ship with a neutral flag is not actually neutral, the warship has the right to visit and search the ship, potentially then diverting it from its originally planned course or discovering that it is not actually a neutral ship and can then potentially capture it as a prize. Now, enemy merchant ships are automatically subject to capture, but not attack, unless they're making an effective contribution to military action. The effective contribution to military action can be something such as laying mines, gathering intelligence, cutting submarine cables, or using physical violence. It can also be if a merchant ship is now acting as an auxiliary vessel, it's incorporated into or assisting the military's data gathering systems. And also if a merchant vessel is resisting orders from a warship to stop for a visit and search issued by an opposing naval commander. Now, neutral vessels, including neutral merchant ships and neutral auxiliary vessels and warships to a certain degree, are not subject to capture or to attack unless they're found to be making an effective contribution to military action. Yeah. So such belligerent actions can be similar to the ones previously discussed of actual use of force or direct military support to the efforts of a opposing power in the conflict. Now, while these are all things that are valid to be targeted, there are also, under international humanitarian law, entities that are prohibited from being targeted. These include hospital ships, coastal rescue craft, life raft, vessels that have surrendered, civilian passenger vessels, humanitarian vessels, and vessels that have been previously protected due to an agreement between the parties to the conflict. These vessels must be innocently employed in their normal role and must submit to identification and inspection when and if required by parties to the conflict. And they're also not allowed to intentionally obstruct the movement of combatants by getting in the way or blocking a path into a strait or sea. And that, broadly speaking, is the international humanitarian law framework for the conduct of hostilities. Very briefly, prize law. Belligerent vessels have the right to capture enemy vessels outside of neutral waters. You also have the right to visit and search neutral merchant ships if there is reasonable ground to suspect that the ship would be subject to capture. Big overview of the procedure is that the initiates typically with a warship's right to visit and search a ship under reasonable suspicion that the ship is not actually acting in a neutral capacity. Upon discovering that a ship has been captured as an enemy merchant ship or has been searched and determined to be not neutral, the warship has the option to capture or destroy the ship. Granted, either way, the crew and passengers of the ship must be taken care of and are not left to sit on a sinking ship. If the warship decides not to capture the ship, once a ship has been captured, it is then the choice of the capturing party if they wish to condemn the ship and proceed to prize court adjudication or release the ship and return it to the owner as in a reasonable time frame under the intricacies of the conflict. In a prize court adjudication, the judge can determine in a specific prize court whether the capturer is afforded the goods on the captured vessel itself, or if the capturer needs to return the vessel to its original owner, which at times can also include financial restitution for the capture in certain egregious circumstances. A variation of prize law is, for all those pirate fans out there, booty law, which is a concept that military and governments can use if they capture an enemy warship or auxiliary vessel or goods and services in furtherance of warships and auxiliary vessels. They are permitted to not take it to prize court adjudication, but use it in their own war effort if they so desire. Lastly, we have the principle of maritime neutrality. In neutral waters, which are composed of internal waters and territorial seas, and hostilities are prohibited, absolutely prohibited in a neutral state's territorial seas. This includes not only conflicts in the water themselves, but also the use of military aircraft, and even missile strikes cannot pass over the airspace of a neutral state in a naval conflict. However, the exclusive economic zone of a neutral state is open for hostilities as long as the parties to the conflict exercise due care for the rights and objects of the coastal state. Lastly, neutral ports within territorial seas or exclusive economic zones are open to parties to the conflict for supply restocks and seaworthy repairs. It is important to note that no repairs to bolster the military or fighting capability of vessels may be carried out at these neutral ports. It is solely the exercise of pairing up leaks and holes or damages to the ship that would impair its ability to navigate through the seas under its own power. So broadly, that is the framework of the law of naval warfare under international humanitarian law, which begs the question, what's next? While the San Remo Manual was a welcome codification of the law of naval warfare, it only tried to codify existing law and made very few attempts to address adapting law to commercial and technological developments, which even since the 90s, there have been quite a few, as an understatement, which is why even by the early 2000s, people were again calling the law of naval warfare outdated. This criticism has only grown in validity as technology has progressed. So while naval warfare strives to balance those belligerent rights and the neutral rights, it is getting increasingly more difficult to practically accomplish. For example, between 1990 and 2021, the volume of cargo transported by ships more than doubled, from 4 to almost 11 billion tons. And there were 30,725 cargo ships in the world, in the world's merchant fleet in 2021. It is thoroughly unfeasible for a warship of a party to the conflict to thoroughly search a modern container ship carrying at least hundreds, if not tens of thousands of massive shipping containers. Additionally, complicating the process, many commercial vessels now use flags of convenience. It is estimated that nearly 2/3 of the world's ships are registered in states to which they have no connection. Warships cannot stop and search every single ship they come across, but if flags have lost their status as conclusive evidence of allegiance to either be an ally, a party, or an enemy, they have few options short of total blockade or a strictly enforced maritime exclusion zone to ensure effective control of an area of the sea. And as the world has seen recently with the Russian blockade of Ukraine and the Black Sea, blockades in the modern era can have enormous economic ripple effects that impact the entire world. Another example, 95% of intercontinental global internet traffic travels over undersea cables. While these cables are valid targets if outside of neutral territory, as they do have a military use, it would have ridiculous ripple effects for global communication, the economy, and security of almost every state on the planet. And under the law of naval warfare, there is not sufficient protection for these cables that, while do have some military advantage, have a wildly disproportionate effect on neutral parties to a conflict. It is these sort of issues that highlight the need for further modernization of the laws of naval warfare to best fit our current reality. And with that, that concludes my presentation. Thank you so much for listening, both myself and the Red Cross greatly appreciate it. I see that we are over time, but I will take a look at questions and try and answer one or two if anyone would like to stay on. But if not, thank you for attending. I hope you learned something and have a fantastic day. Up here. All right. So one question is, how does one identify neutral waters? And how neutral waters, broadly speaking, are identified and prescribed areas. The most common neutral waters are in territorial seas, which are that sovereign area laid out by UNCLOS. And also there are neutral waters in international straits and other transitional areas of the sea that cannot that are used so thoroughly and trafficked so thoroughly by so many people that they are protected from conflict. One example of an auxiliary vessel would be a cargo ship or a fuel ship that sails alongside a warship. So there's say you have a destroyer, a military convoy would include auxiliary vessels that might have surveillance technology, repair kits, food, fuel, that sort of thing. I think that is all the questions I see. Oh, that's one. The United States is not officially party to UNCLOS, but has acknowledged that it is now acknowledged that it is customary international law and has committed to following the provisions of UNCLOS in their conduct on high seas. See, there's a question about if there's a quarantine or spreadable sickness that could affect many, would the ship be seized and taken to a nearby country or left at sea for doctor's care? That is not quite under international humanitarian law, but if it was as part of a conflict, if this was, say, a military auxiliary vessel where there was some sort of outbreak, and they fell into the power of another party to the conflict, the members of the ship would be protected under the Second Geneva Convention and the Third Geneva Convention as prisoners of war, and specifically protected as people sick at sea. So they would be taken care of, but I can't comment to in wartime whether they would be quarantined or where that ship would actually go. And then the presentation the slides will not be available to download, but the presentation itself will become available on our YouTube page shortly after the presentation concludes. The Newport Manual on the Law of Naval Warfare, I should read the question out loud. What place do you see for the Newport Manual on the Law of Naval Warfare? The Newport Manual is I think one has come out in the last year. I think it is a very useful restatement of the law of naval warfare. It relies on a lot of customary international law, the San Remo manual, military manuals of various countries, and sort of indicative of sort of opinion jurors and some of the provisions that are not just restatements, but are taking a position that might not be customary international law may become customary international law if they are continually proven to be accepted. But it is not, as the Newport Manual is a manual and is not a binding treaty or law on any state. All right, that is all of our questions. I hope this has been informative. Thank you all so very much for attending. I really appreciate it, and I hope you all have a wonderful rest of your day.